Washington state has one of the most tenant-protective breaking lease frameworks in the country, consistent with the state's overall heavily regulated landlord-tenant environment. The governing law is found in the Residential Landlord-Tenant Act, RCW Chapter 59.18, which provides detailed provisions covering early termination rights, the landlord's mitigation duty, domestic violence protections, and specific rules that limit what landlords can charge when a tenant breaks a lease. If you're dealing with a broken lease in Washington, the statutory framework is extensive and the consequences of noncompliance are significant. Let's start with the landlord's duty to mitigate damages, because Washington has one of the strongest mitigation requirements in the country. Under RCW 59.18.310, when a tenant breaks a lease and vacates, the landlord has a clear statutory duty to make reasonable efforts to re-rent the unit. The landlord cannot hold the departing tenant liable for the full remaining rent without making genuine efforts to find a replacement tenant. Washington courts have consistently enforced this mitigation duty. The landlord must advertise the unit, show it to prospective tenants, and accept a qualified applicant. If the landlord fails to mitigate, the departing tenant's liability can be substantially reduced or eliminated, even if the tenant broke the lease without legal justification. The departing tenant's liability is limited to rent for the reasonable period the unit remains vacant, despite the landlord's good faith re-rental efforts, plus any reasonable costs associated with re-renting, such as advertising expenses and unit preparation. In Washington's generally strong rental markets, particularly in the Puget Sound region, landlords can often re-rent within a relatively short period, which limits the departing tenant's financial exposure. Washington has specific provisions regarding early termination fees. Under RCW 59.18.310, if the lease includes a liquidated damages clause or early termination fee, the amount must be reasonable and reflect the landlord's actual or reasonably anticipated damages. A fee that functions as a penalty, disproportionate to the landlord's actual losses, can be challenged and may not be enforceable. Washington courts evaluate the reasonableness of early termination fees based on the difficulty of estimating actual damages at the time the lease was signed, whether the fee amount is a reasonable estimate of anticipated damages, and whether the fee is proportionate to the harm actually suffered. A fee of 1 or 2 months' rent is generally considered reasonable. A fee of 6 months' rent, when the landlord re-rents within 2 weeks, would likely be deemed an unenforceable penalty. Military members have the right to break a lease under the Federal Service Members Civil Relief Act. Washington also has state-level military protections that supplement the SCRA. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. Washington's significant military population, centered around Joint Base Lewis McChord, Naval Base Kitsap, Naval Station Everett, and Fairchild Air Force Base, means that military lease terminations are a routine occurrence. Landlords near military installations should have a standard SCRA termination process in place. Washington has enacted comprehensive protections for victims of domestic violence, sexual assault, and stalking that allow early lease termination. Under RCW 59.18.575, a tenant who is a victim of domestic violence, sexual assault, unlawful harassment, or stalking can terminate the lease by providing written notice and documentation to the landlord. The qualifying documentation can include a valid protection order, a written report from a qualified third party, such as a law enforcement officer, domestic violence advocate, or healthcare provider, or a copy of a police report. The tenant must provide the landlord with at least 14 days written notice before the termination date. When a tenant terminates under Washington's domestic violence provision, the tenant is liable for rent through the termination date, but is not responsible for rent for the remainder of the lease term. The landlord cannot charge an early termination fee. The security deposit must be handled according to Washington's standard deposit return rules, returned within 21 days with an itemized statement. Washington's domestic violence provision also includes important privacy protections. The landlord must keep the tenant's documentation confidential and cannot disclose the tenant's status as a victim. The provision applies to the victim tenant specifically. If there are co-tenants, the remaining co-tenants' lease obligations continue unless they also qualify for termination. Washington also allows lease termination when the tenant or a household member experiences a qualifying health condition. Under certain circumstances, a tenant who needs to relocate due to a health condition that makes the current unit unsuitable may have grounds for early termination, though the specifics depend on the nature of the condition and whether reasonable accommodation could address the issue. Tenants in Washington may break a lease if the landlord fails to maintain habitable conditions. Washington's habitability requirements under RCW 59.18.060 are detailed and specific. If the landlord fails to maintain the premises in compliance with the statutory requirements, and the failure substantially affects health, safety, or the use of the property, the tenant has several remedies, including the right to terminate. Under RCW 59.18.090, if the landlord fails to address a habitability issue within a specified time after receiving written notice, typically 10 days for most repairs, the tenant can terminate the lease by providing written notice. The tenant is not liable for rent beyond the termination date, and the landlord cannot charge an early termination fee. Washington requires landlords to provide specific notice before the tenant must provide notice of non-renewal. For month-to-month tenancies, Washington requires 60 days' notice from the landlord to terminate, one of the longer notice periods in the country. For fixed-term leases, the lease governs. But this extended notice requirement reflects Washington's overall tenant protective approach that carries through to the breaking lease context. Washington also has specific provisions regarding the tenant's obligation to provide notice when vacating. If a tenant breaks a lease, providing as much advance notice as possible, even if the departure is mid-lease, triggers the landlord's mitigation duty sooner and can reduce the tenant's overall liability. A tenant who simply disappears without notice may face greater liability than one who provides notice and cooperates with the transition. From a practical standpoint, Washington's rental market is one of the strongest in the country, which generally works in favor of tenants who break leases because landlords can typically re-rent quickly. Seattle has an extremely competitive rental market. When a tenant breaks a lease in Seattle, the landlord can often re-rent within 2 to 4 weeks for a well-maintained unit in a desirable location. The departing tenant's liability may be limited to just 1 month's rent or less, particularly during peak rental season from spring through early fall. Winter breaks may take slightly longer to fill. Seattle's local ordinances add additional tenant protections on top of state law. Seattle's Just Cause Eviction Ordinance and other tenant protections create an environment where landlord compliance with breaking lease procedures is carefully scrutinized. Landlords in Seattle should ensure their lease terms and breaking lease procedures comply with both state and local requirements. Bellevue, Redmond, Kirkland, and the Eastside communities have similarly strong markets driven by the tech economy. Microsoft, Amazon, Google, and hundreds of other tech companies create enormous demand. Re-rental in Eastside communities is typically quick. Tacoma has a growing market with increasing demand. Re-rental times have shortened as the market has tightened. Spokane, the state's second-largest city, has a more moderate market, but demand has strengthened in recent years. Olympia, the state capital, has steady government-driven demand. Vancouver, across from Portland, has a strong market influenced by both Washington and Oregon economies. The military communities around JBLM, including Lakewood, Tacoma, and the surrounding area, see regular SCRA lease terminations as service members rotate in and out. Landlords in this area should expect military lease breaks as a normal part of operations and price them into their business model. College towns including Pullman, Ellensburg, and Bellingham have seasonal markets where mid-year lease breaks are harder to fill than breaks timed to the academic calendar. One best practice for Washington landlords: structure your early termination clause to comply with RCW 59.18.310's reasonableness requirement. A fee of 1 to 2 months' rent with 30 to 60 days' notice is generally defensible. Avoid fees that exceed 2 months' rent. Washington courts are likely to view larger fees as unenforceable penalties, particularly if you re-rent the unit quickly. Another best practice: begin re-rental efforts immediately upon learning that a tenant intends to break the lease. Washington's strong mitigation duty means that every day you delay marketing, the unit is a day you may not be able to charge to the departing tenant. Document your efforts meticulously, listing dates, advertising channels, showing logs, and when you accepted a new tenant. A third best practice: have a standard process for handling domestic violence lease terminations under RCW 59-18-575. When a tenant provides the required notice and documentation, accept the termination, calculate the date 14 days from notice, process the security deposit within 21 days, and maintain strict confidentiality of the tenant's documentation. Training your staff on this process ensures compliance and protects vulnerable tenants. Washington requires landlords to return the security deposit within 21 days of the tenant vacating, whether the departure is a normal move-out or a broken lease. The landlord must provide a full statement of the basis for retaining any portion, along with documentation of any deductions. Failure to comply within 21 days can result in the landlord being liable for up to twice the deposit amount, plus attorney's fees. For the complete guide to Washington breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.